Hello and welcome back to our channel, Astro Tutoring. My name's Aaron, and today we're going to be going through one of the topics for A-level law, which is ADR, or Alternative Dispute Resolution. Okay, so this is applicable for most major examples, so WJEC, particularly WJEC and OCR, but you can also use it if you're doing AdXL or AQA. Okay, first thing I want to say is you can download these notes pages. There's only a quick 2-page PDF. This is what I'm going to be using to go through as I talk you through the content today. You can take your own notes as you take it with us, or you can go away and do it independently, but this is what we're going to be using, okay? You'll have to bear with me as well. I am trying some new software out, so I'm hoping that it'll work and it'll be okay. But for the meantime, we are going to get started, okay? So ADR, what we're going to look at is, first of all, the 4 main types of ADR. We're going to look at the advantages and the disadvantages of ADR as well, and we will then go back over each one and again discuss individually the disadvantages and advantages for each of the types of ADR. Alright, so we're going to jump straight into it. So let's start off by having a look at the definition. Okay, so the one thing to remember about using the court, and I'm going to write on this black bit here, all right, is that it's extremely costly in both money, okay, so financially, and time as well. It can take a lot of money and a lot of time to get stuff resolved, as we know. It's also extremely traumatic, okay. I mean, if we think about like family law cases, if something is quite serious, and you know, having to wait ages and ages for it to play out or for a decision to come in, it can be extremely difficult. So there are always going to be people, and this is where the definition comes in. All right, so ADR is an alternative means to resolve disputes. Okay, so it's an alternative mean to resolve disputes rather than using things like the courts, for example. So yes, that's the definition. Quite a short, simple one, but it is good to know the side notes there about it being quite costly in terms of money and time. By the way, I have got my fan on. It's extremely warm. If you're watching this by the time it's posted, you'll know the heat wave has been absolutely ridiculous. But yes, that is the sort of gist of the definition for it. Alright, there are 4 main types of ADR, okay? So if you hear me flicking as well, these are my notes that I've taken. Alright, just to talk you guys through it. But yes, so there are 4 main types of ADR. Again, we're going to discuss each of them sort of individually. The first type is negotiation. Okay, negotiation. We've then got mediation. Alright, the third type is, I can never spell this word, conciliation. And the fourth is arbitration. Okay, arbitration. So we're going to jump sort of straight into the first one. So let's start by having a look at negotiation. All right. So negotiation is often seen as the most common form, of ADR. All right. It usually consists of the two parties. Just discussing things, discussing matters, and coming to an agreement. Okay, the one thing that I think I ought to point out as well is that particularly for negotiation, all right, if the parties say, for example, can't agree, but would rather sort of do it outside of the courts, they can appoint. So they can appoint. Oops, my pen's going funny. appoint a legal rep. Okay, a legal representative, usually a solicitor or someone along those lines. All right. The other thing to note about negotiation is that it can happen at any time, which is something called the settlement at the doors of the court. So it could be that like a trial has been booked, or there's already been a date booked into the court's diary, but you know, the two parties end up agreeing on something just before the trial, before the day before the trial. You know, they can settle at that point. The annoying thing for the courts in this instance is that it can waste their time. All right, their time. But also it can be quite expensive. All right, expensive for it can be quite expensive for the court. All right, so that's negotiation on a whole. Now, if we scroll down, our second form of ADR is mediation. Okay, mediation. Now, I want to again point out for mediation, it is very commonly used in family law. Okay, so things like divorce, all right, or child arrangements. All right, for divorces particularly, I know it's changed a little bit since 2022 when they introduced. Oh, you don't need to know this, but I think it's 2022 when they introduced no-fault divorces. There's actually a program called MyAns. Okay, so basically it's a mediation service. Again, not something you need to know an awful lot of detail about. For those looking to divorce, all right. It's sort of like a, I guess, what would you call like a final, not a final step, but a final try to see if anything can be reconciled. Okay, so back to the actual sort of main point of mediation. If I can get my pen to work. All right, so with mediation, okay, it's important that a neutral, okay, so somebody who is not going to take sides, a neutral third party comes in. Okay, so the neutral third party comes in, and they will sort of help to reach parties. They'll help them reach a compromise. Okay, they'll help them reach some form of compromise to do with the case. But okay, and this is a very big factor here. Okay, the two parties are still, okay, they are still in control, and they get the final say. Okay, so the mediator can't decide anything for them. They can help them again see if there's anything going on that maybe they can settle on together, but they can't decide for them. All right, I'm just going to flip over to my next page of notes now. These are the notes that I actually took when I was in lesson. All right, so another thing is that we've already talked about the common ground. Okay, so that's something that the mediator will help the two parties establish. Is there a common ground between the two in the case? All right, now like we've already discussed here about the family law side of things, Mediation can be used in commercial disputes, okay, so things to do with businesses, but it is typically used in family law, in family disputes, and again, we've already discussed how the parties are expected to go through mediation through the form of MIAMs before the divorce proceedings. And the one disadvantage to mediation that is the biggest one that will more than likely, if you get asked to evaluate the forms of ADR, this is definitely one that you need to be mentioning, is that there's no guarantee that the dispute will be resolved, unfortunately. Alright, absolutely no guarantee. So that's definitely something that you need to be bringing up. Let's go down to our third form of ADR. Okay, so our third form of ADR is conciliation. Oops. Conciliation. Okay, so again with conciliation, a third party is instructed to help out, but with conciliation, the third party, I always describe this as plays a more active role. Okay, active role in what's going on. All right. So they will evaluate the case, and again, it's important to note that for both mediation and conciliation, the third party is not acting as a judge. They don't have any legal power. They're purely there as a third party entity. All right, so they'll evaluate the case, and again, similar to the mediator, they'll provide things like common ground for the two parties to sort of look at. Okay, the conciliation side of things is important as well. You need to mention the body, which is ACAS. Okay, so I'll write it on the sides actually. By you, I'll switch my pen colour. ACAS. Oh my goodness, my pen is lagging. I do apologise. ACAS. Okay, so ACAS. So ACAS stands for the advisory conciliation. Advisory conciliation and arbitration services. Okay, ACAS, an important body that you will need to know, or you'll need to mention in your answer if you're asked about this. Okay, so ACAS, Mr. Nader, will usually get involved if it's like an employment dispute. If it's an employment dispute, particularly, obviously they do get involved with other things, but that's where they sort of mainly come in. They also provide legal positioning advice. Okay, so where does the party stand? It's totally impartial, so there's not any taking of sides. And again, like I've already mentioned, both parties they're in control. Okay, so no one makes any decisions for the parties. Yeah, and how they want to go about doing certain things. Okay, and then our final form of ADR is going to be arbitration. Now, arbitration is quite a big topic in itself, and you'll see why. So, arbitration, okay. So, what's the main thing to remember with arbitration is there is, again, a third party here, but they are usually an appointed an appointed private arbitrator. Okay, they will usually be someone with a specific legal knowledge of a topic. And arbitration is mainly used in the construction or the building, like the building industry. We'll talk about that shortly, but it is something to note. Okay, so it's used in the construction and building industry. The construction and the building industry. Now, there is an act that I want to draw your attention to. Okay, so the Arbitration Act of 1996. Okay, the Arbitration Act of 1996. What this allows parties to do is have a private hearing. Okay, so it tends to be like not public. Okay, there's also a choice in how the cases are heard. Okay, so they can be in writing or they can be in person. Usually, if it's in writing, obviously both parties will submit their cases to the arbitrator, and the arbitrator will have a look at both of them. It is usually in writing, but obviously, they like I said, they have that choice. All right, so that's one thing to mention about the Arbitration Act. That's what it sort of allows or permits. There's another important thing that we need to discuss as well. This is where we're talking about the construction and the building industry. All right, and that is and I'll quickly switch colour here as well. A Scott v. Avery clause. Okay, a Scott v. Avery clause. Now, a Scott v. Avery clause is obviously referring to a case, but it's mainly found in things like building contracts. Building contracts. And what the Scott v. Avery clause says is that should anything happen, right, rather than go to court, a private arbitrator, a private arbitrator is to be appointed. Okay, to have a look at what the dispute is. Okay, to sort of see what they can do. All right. The good thing about the Scott v. Avery clause as well is that again, both parties have the freedom to choose the appointment process. However, and there's this big however, most of the time, all right, the clause will say that the arbitrator will be appointed by the RICS. Okay, so the Royal Institute of Chartered Surveyors. Obviously, chartered surveyors, they have it's meant to have a deep knowledge of buildings and contracts, etc., etc. So they will usually have to be a surveyor under the RICS scheme. Okay. Now, the reason I've got the advantages and disadvantages box under arbitration is particularly because there's been a pattern of exam boards looking at arbitration as a whole and wanting students specifically to focus in on sort of the advantages and the disadvantages of arbitration. So that's what we're going to do for the last bit of this video. All right, so only very short, sort of not easy things to remember, but things that would make obviously sense. So obviously there's the freedom. So the freedom of both parties to choose how the arbitrator is appointed. There's also the freedom to choose whether the case is heard in writing or in person. All right. There's also the freedom to choose whether the venue is, if it is in person. All right. And the second biggest one is the privacy. Okay, privacy. It's not an open hearing, so it's not like anyone from the public can just walk in. so that's why it appeals to quite a lot of people. In terms of disadvantages, okay, so the arbitrator is obviously going to be someone who has somewhat of a legal experience, but that doesn't stop things like complex legal issues arising. Okay, complex legal issues arising. That could happen at any point. Another thing as well is, while generally ADR does tend to be cheaper, for a professional arbitrator, it can still be extremely expensive. Okay, extremely expensive. And the biggest thing, again, when we talked about initially at the start of the video, with ADR being a sort of an alternative because things take a long time, with complex international cases or arbitration services, is no quicker than court, really. Alright, so that sort of sums everything up. These very rough notes, okay, obviously as I'm talking you probably want to be making more thorough, more in-depth notes, especially with the note points I've made on the side. Any questions, pop them in the comments. But like I said, these 2 pages will be available to download below. It's just a Google Drive link, so you can just literally just download it for free. So if you're in the middle of revising or would like to get ahead, especially now with the summer coming up, yeah, feel free to download it. Like I said, any questions, let me know. But until next time, happy revising, and we shall see you very soon.